Aloha and welcome to Health America, NAMI Hawaii, and Treatment Advocacy Center as we present today's Treatment Advocacy Center's Assisted Community Treatment Virtual Training. And today we're going to just learn a little bit about this amazing program. There's a lot more to it than just today's presentation. But first off, I want to thank our wonderful sponsors, Sutter Health Kahi Mohala, Atherton Family Foundation, Hawaii Psychiatric Medical Association, Mental Health Kokua, and so many others who helped to bring this training to our islands. So we're so grateful. And I wanted to just share a little bit about what NAMI is about. And NAMI is the largest grassroots mental health organization in the mainland. And NAMI partners a lot with Treatment Advocacy Center in the mainland and to bring a lot of this type of education. We provide free support, information, education and awareness, and we have amazing programs that are like support groups for family members, education classes for family members, as well as people living in recovery. We also do CIT, Crisis Intervention Team Training, which is teaching officers how to communicate, de-escalating, so that people with mental health issues don't end up in the prison system. And so a lot of our partners here today are also part of that CIT training. And we have our walk coming up October 10th. This is a great way to connect with our community, saying that mental health matters. Contact us for more information. And now we're going to go to Brian Talisayan, who is our wonderful friend. He is an amazing, amazing Executive Director for Mental Health America of Hawaii. And go ahead, Brian, Hawaiian Brian, it's all yours.
Thank you so much, Kumi. I am so excited to see all of you here to kick off this critical training. It's so nice to see so many familiar faces. It's distracting to see you at the same time, but I'm happy you're here. And thank you, Kumi, for all that NAMI Hawaii does through your leadership. We're so grateful to have you as a partner and to call you friend. For more than 75 years now, MHA Hawaii has been one of Hawaii's leading mental health education and advocacy organizations. We've been focusing on the promotion of mental wellness through education, advocacy, and services. In everything we do here, we place significant emphasis on the elimination of the stigma associated with mental illness and advocate for continuous improvement to the overall care and treatment of those living with it and their families as well. Some of our key programs include youth and mental health first aid certificate classes, suicide prevention education for youth and adults, wellness and resilience trainings, and of course, consumer and legislative advocacy. You can find more information about us on our website at mentalhealthhawaii.org, on our Facebook at MHA Hawaii, and on our Instagram pages at Live Na'au and at MHA Hawaii. Again, thank you everyone for being here and for the vital role you play in the mental wellness of our community. I'm so excited to help be a part of kicking this off. Thank you.
Thank you, Hawaiian Brian. We have to say that because there's two Brians on our panel today. But we also now want to introduce our wonderful friends and our partner, Sutter Health Kahi Mohala. They have just always been a great partner with us in many of our education programs and conferences. And we have our wonderful CEO, Claudia Christ. We're going to give her a few minutes to share now. Thank you, Claudia.
Thank you so much, Kumi, and thank you, Kumi and Brian, for allowing me to extend my greetings and true appreciation to all of you. I'm the CEO at Kahi Mohala, and we serve Hawaii's children and adolescents, as you know, as well as adults through a contract with Hawaii State Hospital. And we are the only freestanding psychiatric hospital in the state. It's an absolute honor for us to be able to support this initiative and these two important organizations, NAMI Hawaii and Mental Health America Hawaii. I'm so grateful to them for their leadership and for being such strong advocates in the community. On behalf of Trisha Kajimura and I from Kahi Mohala, thank you to the staff, the board and volunteers at NAMI Hawaii for providing such a crucial support for individuals struggling with mental health conditions and for their family members. Your service and your services provide help and hope where it's needed the most. And this training is really so very timely. The individual and societal impact of the pandemic are taking a toll on mental health of so many. We know firsthand that there are people who, for a variety of reasons, we've not been able to get the help they need. I know that many of you have been struggling with this very issue, and the pandemic really only exacerbates and highlights the need. Would it be acceptable if we had this issue, if we were talking about heart disease, difficulty breathing, or some other serious medical condition? Not likely, but here we are. This is why it's so wonderful that you are taking time out of your extremely busy schedules to participate in this training. You are the ones who are going to help people get access to care, and in doing so, you're also helping to decrease the misunderstanding and often discrimination associated with mental health conditions. I look forward to meeting all of you in person, hopefully sometime soon, and continuing to work together on this important issue. Mahalo, and have a wonderful session.
Thank you, Claudia. We're so grateful for you and your friendship. And now I'd like to introduce Betsy, who has just been phenomenal. She's been behind the scenes. She has helped write the grant to get some of the funding to get this training to the islands. She has been just a great friend, a great colleague, and we're so grateful to have you as our partner. Here is Betsy Johnson with Treatment Advocacy Center.
Good morning, Kumi, and good morning, everybody. Thank you so much for inviting us to present to you today. It's been just a real joy working with you and Kumi and working with NAMI Hawaii and Mental Health America of Hawaii. So I'm going to ask my assistant, Amy, who I will introduce in a little bit, to share our slides. Thank you. So we've got a lot of information to share with you, so I apologize. I'm going to be talking fairly quickly. I just want to make the best use of our time with you today. So first, before I introduce myself and my colleagues, I just want to quickly review the agenda. Here we go. So I'm just going to briefly introduce you to the Treatment Advocacy Center. Then I'm going to turn it over to my colleague Brian, who's going to talk to us about assisted community treatment. I just want to let you know, we may slip and call it AOT. Hawaii is unique and is used to the term ACT. So just forgive us, but we're all talking about the same thing. After Brian does that, he'll kind of briefly go over Hawaii's law and let you know where to find more information. Then we'll turn it over to Amy, who will talk about the learning modules, and we'll share information about our AOT Learning Network, and then talk to you about some technical assistance availability. And we'll have time at the end for some questions. Brian, Amy, and I will stay on afterwards if you still have more questions and we run out of time. Next. So the Treatment Advocacy Center, if you're not familiar with us, we are a national nonprofit organization based in the Washington, D.C. area. Our founding father is E. Fuller Torrey. We focus primarily on individuals with severe mental illness. And when we talk about severe mental illness, we're talking primarily those individuals with schizophrenia and bipolar disorder, many of whom lack insight into their illness, so they have difficulty adhering to treatment. Next. E. Fuller Torrey, if you're not familiar with him, he is a famous psychiatrist, written a number of books, including Surviving Schizophrenia, which is now in its 7th edition. It's our mission that he has developed is until there is a cure for serious mental illness, we are going to work to improve the lives of those with adverse consequences of serious mental illness. You're going to hear from my colleague Brian Stetton. Brian is an attorney. He wears the legal hat on our three-legged stool here, which makes up the implementation team at Treatment Advocacy Center. Brian will talk a little bit about Kendra's Law, but what he may not tell you is he actually drafted that law for the state of New York. It was one of the premier AOT law in the country, and it's one which many states have used to replicate or to borrow from. Amy is a licensed social worker. Amy worked on the ground in an AOT program for many years. She helps, well, she wears, again, the mental health professional hat on our team, and she has expertise in implementing many evidence-based practices, including assertive community treatment and IDDT treatment. And then I wear the family and advocate hat on our team. Prior to joining TAC 5 years ago, I was at NAMI, Ohio, where I worked on getting our AOT law passed here in Ohio, which is where I'm based here in Ohio. Now we've shifted focus onto implementing it not just here in Ohio, but around the country. So one last thing before I turn this over to Brian. Next slide, Amy. One thing that we're quite proud of, both, well, Amy, Brian, and I, and our boss, John Snook, who is Executive Director of Treatment Advocacy Center, as well as Dr. Mark Munitz, who is one of the co-developers of the sequential intercept model, if you're familiar with that, and his colleague, Dr. Dev Hudra. The 6 of us developed an AOT white paper, which is available on our website. And it is the kind of the foundation from which a lot of the information that we relay here is based, and it helped formulate the protocols that we'll talk to you about later this afternoon or later this morning. So next, I'm going to turn it over to my colleague Brian Stetton, who will talk to us about what is AOT and why it's important.
Thank you so
Brian,
much,
take it
Betsy.
away.
Okay, I will. Thanks. Can everyone hear me? Oh, great to be with you. Aloha, everyone. I'm coming to you from my basement in Washington, D.C. And as some of you may know, there had actually been hope that we would, from the group of us from TAC, would be coming to Hawaii this year. Obviously, COVID had other ideas, but we really very much hope that that's going to happen next year. We would love to get out there, not just because it's paradise on earth, but because we think there is enormous untapped potential in this law, this thing we're calling assisted community treatment. I know that's the law that's been on the books in Hawaii for many years, and I know there's been a lot of frustration that not nearly enough use has been made of it. And we really look forward to the opportunity to work with all of you and get to know all of you to change that reality, because we think this can truly be a game changer for people with severe mental illness who are just not engaging with services under the way they are made available now for reasons that we will discuss. So if I could have a slide change, please. One thing I'd like to say in starting out before we kind of describe this concept of ACT, and if, again, as Betsy said, if I call it AOT, please forgive me. One thing we really want to make clear before getting into what AOT or ACT is and some of the philosophical underpinnings beneath it, we want to really make it plain that this is not a cure-all for everything that ails public mental health. I think sometimes people in their excitement about AOT may oversell it a little bit and suggest to you that all of the frustrations that you all are dealing with on a daily basis working in the public mental health system are going to be suddenly magically erased by having this new tool at your disposal. And of course, that's not true. You know, there are many things that frustrate all of us who work in this area around the U.S. Are grappling with. And I've ticked off just a few of them on this slide. I am sure the folks on this webinar could fill many more slides with additional bullet points, but just to recap briefly some of the major things that we are challenged by in this area. We obviously have really shameful underinvestments in community-based care, so that even people who are seeking services are often not able to receive the entire package of community-based treatment that they need to stay safe and well. We have terrible shortages everywhere that our organization works of inpatient psychiatric beds. No state is really doing a great job in making sure there is enough inpatient treatment available so that when people are in acute crisis and need to be in a hospital, they get to stay there long enough to ensure that they're released back into the community in the most stable possible condition and have the best odds of doing well once they are released. We also have terrible shortages everywhere we go of mental health professionals, from psychiatrists and psychiatric nurses all the way down through all the various professions that are necessary to make the system work. This is a particularly acute problem in rural areas, sparsely populated places. We have as well a tremendous need everywhere for new strategies to be brought into the law enforcement sphere. We know that many people are arrested, and we have a criminalization of mental illness that's going on everywhere, where we have strategies and ideas of ways to divert people from the criminal justice system they don't belong in, because we know they need treatment much more than they need punishment. We have a great need to actually start getting some of these great ideas into practice in many places. And none of these problems are going away the day we do AOT. AOT is not designed directly to address those particular problems. It's about another universal challenge in public mental health that I think doesn't get nearly enough attention, and that's the one I've highlighted here in red at the bottom of the slide: the problem of treatment non-engagement, right? The fact that we have some people with severe mental illness who, by no fault own, for reasons we'll discuss, have great difficulty engaging in the services that are made available to them. So that even in a particular person's case, if we're able to solve all these other problems we've just ticked off and offer somebody a really great package of care, we have folks who are going to drift away from that, who are not going to stay engaged with their treatment the way people tend to with other types of illness. That's what AOT is about. And although it's not going to cure some of these other problems, I think we should acknowledge that this problem of treatment non-engagement is increasing the pressure that we have with all these other issues, right? It's creating this core of what we sometimes call super utilizers, who we're serving so inefficiently that it is making some of these other resource deficits that much worse, because it's preventing us from providing everybody as much care as they need. So let's move on and just talk about what some of these issues related to treatment non-engagement are. And we often say we're talking about folks who are caught in the revolving door. Revolving door is plural, I should say, because it's the revolving door of the public mental health system, and as well the revolving door of the criminal justice system. People who are coming in again and again and really causing so much heartbreak because of their inability to engage with treatment. Let's talk about what some of the major consequences of treatment non-engagement are. We can move to the next slide, please. Thanks. The first one I think we want to address very gingerly and carefully, because the last thing any of us who work in this area want to do is further perpetuate stigma. We certainly don't want people to ever be afraid of their mentally ill loved ones or neighbors. And so I think want to speak very gingerly about the reality of violence and crime as a consequence of treatment non-engagement. You know, in the wake very often of some terrible tragedy that's committed by someone who has untreated severe mental illness, those of us who are mental health advocates are often very quick to remind the public, as well we should, that people with mental illness are in fact no more dangerous than anyone else. And while we need to keep repeating that message, we should also be aware that there is an underlying reality somewhat masked by that. You know, for one thing, when we speak about people with mental illness in general, that is a vast category of folks. That's 1 in 5 of us. It's undoubtedly many people who are even listening to my voice now. And that obviously includes lots of conditions like, you know, anxiety or OCD or many others that we would never necessarily associate with people engaging in any kind of violent behavior. But even if you are talking about the most severe mental illnesses, right, things that cause psychosis and delusion, such as schizophrenia, severe bipolar disorder, schizoaffective disorder, even with those diagnoses, the fact is most people who have the most severe mental illness on any given day are not at risk of committing violent acts because they are receiving treatment. And we have study after study that tells us that with treatment, any association between severe mental illness and violence and crime is removed. But when we're looking at that subset of a subset, right, folks who have the most severe mental illnesses and are not receiving treatment for it, there is nobody who can tell you that untreated severe mental illness is not a risk factor for violence and crime. In fact, it's associated with about 10% of U.S. homicides, which is by no means the majority. It's a minority in terms of the whole picture, but it's far beyond the numbers of folks that we're talking about, right? Severe mental illness is associated with about 4% of the population. Most of those folks on a given day are in treatment. So when you're looking at that small group responsible for 10% of homicides, it's pretty significant. And of course, more typically on an everyday basis, we're going to be associating untreated severe mental illness with more prosaic crimes, property and drug crimes that people may commit in their attempt to self-medicate, sometimes assaults against family members, etc. So this is real. Let's move to the next slide, please. Another significant consequence that we've all seen in heartbreaking fashion is the reality that people with severe mental illness often rack up staggering numbers of hospitalizations in a short period of time. And the reason for that is that you can only keep somebody in a hospital so long as it takes to stabilize them, to remove that danger to self or others that was the reason for that involuntary commitment. Once that person is stable, they now have a constitutional right to return to the community. But if you have not addressed that non-engagement with treatment that has led to that hospitalization in the first place, it is almost inevitable you are going to see that person again very soon. And so this creates this vicious cycle. And of course, the most awful aspect of that is we know from research that we are pushing recovery further out of reach for folks by allowing them to rack up the psychotic break after psychotic break, right? Each time that happens, it's lowering a person's ceiling for how much they have a potential to live the life they would choose if they did not have this illness in the first place, because it's just mileage on the brain that does not have to happen. So, it's really kind of a collective shame, and that I think we all should really be resolved to address and change. Next slide, please. And even for those, which would include nobody, I'm sure, who's on this webinar right now, but even for those who are not as focused on the human toll, right, the suffering and the tragedy that we're ticking off right now, even for the average person on the street who may not be touched by this themselves, there is a budgetary impact that affects every citizen, whether they care about people with severe mental illness and their plight or not, right? Because the way we are responding to this problem, typically through crisis response, right? The cost of picking up the pieces again and again when people lapse into crisis, through psychiatric hospitalization, through arresting people, through incarcerating and prosecuting them. All of these are enormously expensive interventions, and it is fair to say that our poor job that we've done as a country in addressing non-engagement with treatment has really stretched our criminal justice and mental health systems beyond a breaking point. So let's talk about what is the cause of non-engagement with treatment. And let's move to the next slide, please. It's obviously a complex question. I don't want to suggest there is one simple answer in any particular person's case. You might have many reasons why that person is not engaged with treatment. But one I think we really need to focus on and should not lose sight of is this problem of anosognosia, lack of insight into illness. The fact that there are some people with severe mental illness who, by no fault of their own, simply are not aware of their illness and need for treatment. They cannot see it, no matter how painfully obvious it is to everyone around them. And, sometimes we call this denial, and just kind of using terminology loosely. Someone will say, my son's in denial about his mental illness, doesn't want to take his meds. I think it's important for all of us to recognize the difference, right? Denial is a universal human defense mechanism. It's something we've all practiced at one time or another in our lives. And when you're in denial about something, you actually do know the truth. You may need the help of a professional or a good friend to help you coax that to the surface and face it and move on in life. That's not what's going on with someone with anosognosia. This is a neurological condition that is a corollary for many, by no means all, people with severe mental illness. And sometimes it's a fixed situation and sometimes it comes and goes. But when a person is experiencing anosognosia, they don't know the truth deep down. They are certain to their core that they don't have an illness. And when you understand that, right, from that person's point of view, not wanting to engage with treatment makes perfect sense. It's perfectly logical, especially when we acknowledge there are some, let's face it, unpleasant negative side effects to some of these meds we wish we didn't have. But when you are not seeing the bigger picture of what this is doing for you and only seeing the negatives, of course you are not going to want to have anything to do with that treatment. And so we have to understand the need to, get beyond frustration with people who are in this situation and figure out how we're going to help them. I just will mention real quickly, you see we have a picture of brain scans here in the slide, where you're looking at the brains of two individuals with severe mental illness, one who has insight into their condition, the other who does not. And you can actually see brain activity happening. This is a moment where these individuals are being asked to perform a self-reflective activity. And in that brain on the right, you can see synapses firing that just isn't happening for the other person. So I think this really brings home that this is about dysfunction of an organ of the body, no more the person's fault, no more the reason for us to be frustrated with that person than would be dysfunction of any organ of our bodies. There's a study I also have mentioned briefly on this slide, published in Psychiatric Services in the year 2006, which looked at about 300 people who had chronic non-adherence to treatment. And most of these folks did not have anosognosia. Well, they started this study with baseline interviews of these 300 individuals and found that 2/3 of them actually did understand during these interviews that they had a mental illness. So that really speaks to the fact that there are lots of reasons besides lack of insight that people might have trouble complying with treatment. But that third of the sample who insisted they did not have mental illness, when this group of 300 was tracked over time, there were extraordinary correlations between that third of the sample and how seriously people were suffering as a result of non-adherence with treatment. So that was the group that was most likely to be hospitalized, most likely to have severe symptoms, most likely to completely cease meds as opposed to tapering off or missing doses. On metric after metric, we find that if we really want to do something meaningful about non-adherence with treatment, a person's lack of insight is really the ball we need to keep our eye on. Next slide, please. And this kind of brings me to my bottom line on anosognosia. And here I like to invoke that corny movie, no pun intended, Field of Dreams. Those of you who've seen it will remember that iconic line, right? If you build it, they will come. And there's folks who say that very thing about the mental health system, right? That our problem is simply that we haven't done a good enough job making sure there are good community-based services available to everyone who needs them. And if you would simply do that, people would come out of the woodwork, they would come flocking into that system and stay engaged with treatment. And I hate to put myself in direct opposition to that point of view, because I think with respect to plenty of people out there who are serving poorly, that's probably a fair statement. There are some people who would do a whole lot better if we simply did a better job ourselves of making sure services were there. But I think we're kidding ourselves if we think that that's all we need to do for people who are also struggling with anosognosia or lack of insight, right? Because no matter how great a package of services you're offered, if you don't see them as relevant to a problem that you have in life, you're not going to have any interest in that. So by all means, let's work together to build that great system of community-based care, but also recognize the need to do something in addition for folks who lack insight. And that's where this legal mechanism of ACT, assertive community, assisted community treatment, comes into play. Next slide, please. So let's turn now to what ACT is. This is a strategy to address the natural inclination of some people not to adhere with their mental health treatment. And this is a collaboration between the mental health system and the court system. It is a form of civil commitment. We're all familiar with the more conventional civil commitment, where it's about a person in crisis who needs to be in a hospital, and even though they may not choose hospital care at that moment, we as a system are making that decision for them, recognizing they're not in a position to know their best interests. This is about civil commitment to outpatient care for a person who is not currently in acute crisis, who is capable of surviving safely in the community, but who has demonstrated through their history that they have this difficulty in staying engaged with treatment on a consistent basis, which has led them to repeated hospitalizations and or arrests. And this is a means of kind of leveraging the power of the courts to influence behavior, to help people make different choices than they would otherwise through this tool of civil commitment. Next slide, please. So before really getting into why we think this works, why the studies tell us this works, we should really talk about this court order that lies at the heart of this concept of ACT. It's worth wondering why this court order matters. You know, under typical legal situations, those of us who are attorneys who think about court orders, the reason they work is because they have teeth attached to them, right? Generally, people obey court orders because they fear the consequences of not doing so. They know that if they don't do what the judge has ordered, they could be held in contempt of court, which could lead to a person being having their liberty taken, being placed in jail, having fines pile up on them. All of that, we really have to say, is off the table when it comes to AOT. We never, ever enforce an AOT court order through the contempt power of the judge. And in many states, that's actually expressly prohibited, even where it's not. We strongly urge judges never to hold someone in contempt of court for not following this court order, because for reasons we've talked about, if the person's not engaging with treatment, it's not because they have contempt for the court, it's because it's the nature of their condition that they just have difficulty understanding the importance of it. So that typical way we enforce a court order is taken off the table. Another thing we're not going to do is automatically return somebody to the hospital and say, follow this or else you're going to be in a hospital. If a person is not meeting inpatient criteria, if they're not currently a danger to themselves or others, such that they would otherwise be subject to inpatient commitment, we can't say, you know, this is a reason why you're going to be. As a matter of constitutional law, a person has a right to their liberty unless they are a danger to themselves or others. So we're not going to enforce it through automatic rehospitalization. Nor are we going to say that the remedy for a person not taking their meds as ordered by a judge is that we are going to restrain that person and inject medication into them. Forcible administration of medication is something that takes place in a hospital setting sometimes as a last resort. It's not something we want to be introducing into community-based care. So, you know, that's another way that you might expect that we would enforce this court order that we're just going to take off the table from the get-go. So with all these remedies that you might imagine as to why this court order has meaning being removed from the possibilities, it's fair to ask, well, what is the point? And sometimes judges, I kind of lose them at this point in the presentation because they say, well, you're not really giving me any teeth to this court order. It's a paper tiger. What are we accomplishing? As I say, it's a fair question to ask, and there are, in fact, some real points, some real things we are accomplishing through this admittedly fairly toothless court order. Next slide, please. The first one is something we sometimes call the black robe effect, which is simply the idea that being told to do something by a judge has an impact on a person beyond what would, you know, ordinarily be possible by having the doctor say it or having the, you know, your mom say it for the umpteenth time. Having a judge say, this is something that I think is important for you, and just going through the ritual of a court process where the judge has reached this conclusion after having this hearing and hearing testimony in this kind of solemn way. All of us who are members of this society, right, we're all inculcated to think of the judge as an authority figure. And I probably shouldn't say all, you know, I don't want to overstate the case here and suggest that there aren't some people who are not the slightest bit impressed by being told to do something by a judge. There are some that just don't take that any more seriously than they would hearing it from someone else. And AOT is not going to work, or ACT will not work in every case. There are people who this approach is just not going to be effective for. We should acknowledge that up front. But for most people, and certainly the studies tell us, it's a big deal for someone to go through a court process and hear this message from a judge. And in many of our AOT programs, right, the judges will sort of embrace that and kind of take that knowledge and run with it and really try and engage with the person on a personal level, bring them back to court repeatedly through the period of the court order, and kind of reinforce that black robe effect. And, you know, we should also mention that this black robe effect is something that those who work in the system, mental health system providers, are not immune to either. Being told that this is a high priority client of yours, and here are some services that we have determined this person needs, and I as the judge am expecting you as the provider to make sure the person has these services, that they are delivered as promised. That's going to make an impact on the system as well, and make the folks understand that this is a case we really need to take seriously because the judge has identified this person as especially vulnerable. So that's the black robe effect. That's one of the main things we're trying to accomplish through the court order. Next slide, please. The next is what we call rapid response to non-adherence to treatment. And when we say that there is no punishment associated with violating the AOT court order, we should not make the mistake of thinking that means that there is no consequence. You don't want to have an AOT program where nothing happens if the person doesn't follow through with the treatment that's been court ordered. The consequence should take the form of, and we'll look at the Hawaii law to see how this translates in a minute, but essentially we want to make it a little bit easier to get a person in, not to be involuntarily committed again to a hospital necessarily, but to get the person in for a short-term hold to evaluate their needs. That is, when it's become clear that this person is not following what the judge has directed, good faith efforts have been made to solicit that compliance by the treatment team, and now the team has to go to the judge and say, we just can't get this person re-engaged. That gives the judge a reason to say, let's bring the person in to determine what their current needs are and see if we need to modify this court order and in fact decide to move them to an inpatient basis, or maybe they'll tell us something isn't working about the current treatment plan and we can maybe change the terms of it. But it all has to start with us evaluating where they are right now. So this triggers the opportunity to bring the person in for a short-term hold for evaluation, followed by another hearing, another appearance before the judge to figure out where we are going to go from here. And even if the person doesn't meet inpatient criteria and you from there have to release that person back to the community, it's at least an opportunity to reconnect them with the treatment team and have the judge remind them, hey, we all know where this is headed because you have this history, which is why you're in the program in the first place. None of us want you to be back in the hospital. You don't want to be back in the hospital. So here's an opportunity for us to reconnect and work together. And just the opportunity to do that is all the teeth you need to make AOT work. And we have communities after community who are practicing this model and improving that every day. Next slide, please. So, we will talk a lot about the need to have an AOT program. I think it's worth making clear that there's nothing when you look at the AOT law, as we will very briefly in a minute, that talks about doing AOT as a program, right? You see a lot in the law about the opportunity to do AOT as a legal proceeding when a person meets a certain set of criteria. But what we are advocating for in the work that we do with communities around the country and hopefully with many of you in Hawaii is to use that legal authority and build a program around it, something that's not contemplated in the law, but is clearly within your authority as mental health providers, because you have this power to bring AOT cases in situations where people meet the criteria for it. You can create a whole infrastructure, next slide please, where you are attempting to identify all the folks in your community who do indeed meet these criteria. A logical place to do that is upon their discharge from a hospital, right? So we're not just discharging them with a encouragement to stay engaged with treatment, but actually a tool that will make that more likely. And we are, as a program, really resolved to make sure that all the folks who are placed under these court orders get the services they need and the monitoring and attention they need. And we are determined as a system to make sure that folks will be brought back into court and get the kind of response we've already talked about if in fact it's not working out. We're going to make sure programmatically that we are evaluating each person at the end of their term of court order treatment to determine whether it's appropriate to re-up, that is, renew that civil commitment and keep them in the program a little bit longer, or alternatively, if they're ready to graduate. When we are doing all that as a system and are determined to identify as many of these folks as we can who are caught in the revolving door, that's kind of what we mean by building an AOT program. Let's move on. Next slide, please. Another clarification I think is really important is that ACT is often confused with the related concept of mental health court, right? Sometimes people will say, oh, you'll hear this description of this program and say, we have a mental health court, we're doing that already. And I think, and the assumption that you have some mental health courts operating in Hawaii, I hope you do, we should really understand what the difference is, right? Mental health court is a wonderful program. Like ACT, it's something that every mental health system in every community should have. But it's a criminal court, right? It's for folks who are currently in the criminal justice system, who are facing criminal charges. And we have come up with a really great and compassionate and sensible way to help people be diverted from that system, to get them treatment instead of punishment as a way of addressing those specific charges. But, you know, at the end of the day, you've got to commit a crime and have that charge pending against you to be eligible for mental health court. You don't have to commit a crime as the price of admission to be helped through an ACT program, right? This is something that happens in civil court. It is, you know, not unlike mental health court involving some real consequences if you don't follow through. Right, in mental health court, the fact that you can have your criminal charges brought back really does add some teeth to the equation that as we've already discussed, we don't really have at our disposal. So we're much more reliant on engagement strategies and the skill of the judge under the ACT model. And at the end of the day, you know, mental health court is a voluntary program. A person could say, I don't want to be a part of this program, and choose to roll the dice and take the chances that they could beat the rap, and then they won't maybe have to do anything. Because ACT is civil commitment, we are making that decision as a system. We are saying that we would love you to be part of this program voluntarily and to join us. But, you know, if we can't get to that point, we're still going to bring this tool to bear. So there's some very real differences. Most important one is that we are going to be able to help people at a point when they don't have criminal charges pending against them. Next slide, please. And so, yeah, as we've touched upon a little bit already, the fact that this is an involuntary program is something that we all have to keep in mind. But it's not to say that there won't be plenty of people who come into this eagerly and happily, right? Especially those who are viewing this as a ticket out of the hospital when we're using this as a discharge planning tool. The fact is, in the majority of cases, you're going to have folks who say, yeah, I see this as something that can really help me. At that moment, they actually may have some insight into their illness because they've been stabilized through hospital treatment and may indeed welcome having this brought to bear. And you might think, well, what's the point of putting somebody under a court order to do something they are willing and eager to do? The answer lies in just what we know about the habits of folks who are often in this heartbreaking situation, right? There are many people who leave the hospital with the very best intentions, expecting to stay engaged with treatment. They start to do well for a while, and different thoughts creep into their minds, right? They start to think, well, this is going so well, maybe I don't actually need this medication after all. And, you know, the thought process of disengaging with treatment often takes place a couple of weeks after a person's left the hospital. We want to get in front of those thought processes. We want a person to, when those thoughts start to creep in, to remember, oh, actually I have an obligation to a judge who I'm going to be seeing in a couple of weeks. It's not really entirely up to me to decide this. And so that's why we want that court order in place, even for folks who are willingly coming into the program. So it's absolutely great to do this in a way that's non-adversarial, right? Where people are coming into the program happily when we can, which is going to be most cases. But next slide, please. We should keep in mind the importance of making sure, even in those situations, we still get that stipulated court order. We still go before the judge and have the judge review the record and put that court order in place. Not say, well, it's a voluntary agreement, therefore we don't need a court order. We may not need a hearing where there's this adversarial presentation of evidence and the judge has to be convinced of the person's need. The person may be admitting that they meet the criteria, and we can move right to this stipulated court order. But we still want to make sure the person gets that opportunity to interact with the judge, to be congratulated by the judge for making this great decision to be a part of this program, and to come to the understanding that there's going to be monitoring and expectations of both sides. So I am just about out of time. Can we move to the next slide, please? What I've done in the next few slides, and I know this PowerPoint is going to be made available to you, is I have highlighted the real key aspects of the Hawaii AOT law that shows you the legislative language that actually puts this concept into practice in your state. And I wish I had a little more time to walk through how this all plays out under the Hawaii law, but this is something we can talk about, you know, in the time we have afterwards. If anyone's interested, I urge you to take a look at this. These are just excerpts from your law, but I think these are the key provisions that are pretty easy to make sense of and are worth reading for anyone who's going to be working in an AOT program or ACT program. So I am going to leave it there, turn it over to
Brian?
Yes.
Can you do the law in like 3 minutes, at least
If I have 3 minutes, I would love to.
high level overview?
Yeah,
I speak
absolutely.
3 minutes to you.
Okay, thank you so much, Amy. So let's move back a couple of slides to the ACT criteria, which is really the heart of the law. The thing that makes it possible to say in a particular person's case that this individual is in need of this intervention.
I'm sorry. Let me work.
Come on, you're eating into my minutes here. All right, couple more back. There you go. Oh, stop. You got it. Thank you. So what does it take? What we're trying to do in the law here is identify the exact factors that make it clear that somebody is in fact caught in this revolving door. We don't want this law to apply to anybody who's got severe mental illness. And so the law says that to prove to the judge that a person needs this court order, you have to prove a bunch of things. First of all, that the person is mentally ill or suffering from substance abuse. Our organization, I should tell you, are not really big fans of the idea of using this for someone who is not suffering from a mental illness. We really don't think there is an evidence base to suggest that this is going to work with purely as a substance abuse intervention. Not to say there aren't plenty of dually diagnosed folks who this can be wonderful for, but let's focus on the idea of using this with someone who is diagnosed with a mental illness. Right. The second criteria is that you're finding that the person is unlikely to survive safely in the community without supervision, is in need of treatment to prevent a relapse or deterioration that would result in the person becoming dangerous to self or others. In other words, it's not that they're dangerous to self or others now, but they are extremely vulnerable to becoming dangerous to self or others if not receiving treatment under a really highly supervised way. And third, that the person's mental status and the nature of the person's disorder limits or negates their ability to make an informed decision to voluntarily seek or comply with recommended treatment. And that, I think, is where you could really bring in evidence of a person's lack of insight or anosognosia as speaking to why they are unlikely to do this on a purely voluntary basis. The next criteria is that the person has either a mental illness that has caused the person to refuse needed and appropriate mental health services in the community, or has a history of lack of adherence to treatment that has led to them becoming dangerous to themselves or others. So with this part of the criteria, you are really tying the things you've said about their clinical condition to their history, right? We're not just speculating, we're saying, hey, this person historically has demonstrated this difficulty, has been hospitalized repeatedly as a result of their inability to engage with services. The fourth and final criteria is that ACT is essential to prevent the danger posed to the person, is medically appropriate, and is in the person's best interests. So, that's just kind of a common sense way of saying that there is no less restrictive appropriate alternative to meet this person's needs. That is the thing, those are the things that you are going to be wanting to be proved at an AOT hearing. Just briefly, the next slide speaks about how you actually bring this to the court. There is a petition that must be filed. And in Hawaii, that can be done by anybody. It can be done by a family member. The law says any interested party. If you have an AOT program, it's not going to be left to the family member to bring these petitions. It is going to be your program itself that's going to be filing these petitions in the family court, alleging first that the person meets all these criteria. Second, that you're going to allege the actual facts and the beliefs that the petitioner has that support each of these criteria. And finally, that the person actually is present in the county where this petition is filed in family court. You have to attach to that petition a certificate by a licensed psychiatrist or an advanced practice registered nurse who has examined that person and is willing to provide the evidence the court will need to make these findings. That is, come into court and testify by clear and convincing evidence that they have found that the person meets all these criteria, and also present a treatment plan that the court will approve and incorporate into the order, so that we're not just generally committing the person to treatment, we're saying the person is committed to this specific path of treatment. So that's just a quick look at the Hawaii law and how it relates and how it makes this concept of ACT possible in your state. And it's something we look forward to an opportunity to really helping you all put into practice, because the possibilities here are enormous. Can I turn it to Amy? Amy, you're muted. You're still muted, Amy.
Sorry about that, gang. So how can you learn more about AOT? And I'm sorry, I should have changed that to ACT for Hawaii. So we have developed these learning modules that can help you get your ACT program off the ground. So first, let me just talk for a minute about SMI Advisor. SMI Advisor is a joint program of the American Psychiatric Association, as well as it's funded by SAMHSA, the Federal Substance Abuse and Mental Health Services Administration. And its mission is to provide information on all things for serious mental illness. So they have extensive education library where they have free CEUs. They have chatbots. They have one-on-one consultations for clinicians with national experts. I highly recommend going to visit, and it's SMIadvisor, excuse me, .org. So this is the link to our microsite. So Treatment Advocacy Center partnered with SMIadvisor to bring information about implementing AOT. So I'm just going to actually go here. And of course, it's going to take, I don't know how long. All right. So hopefully I am still sharing my screen. Is that correct? And you see the SMIadvisor page? Can somebody?
Yes.
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 Okay,
Yeah.
good, good. Good. So this is the AOT microsite.
Oh, actually, Amy, I'm not seeing that. We're just seeing the link.
Oh, shoot. Let me try
Maybe
this.
if you just do the share screen again, a new share, then you can pick the browser that website is on.
Got it. Here I am. There?
Yes.
Perfect. SMIadvisor microsite. And as I said, our white paper is here for the reading. Just click and download. And here is where you access the online learning curriculum. And there are 8 modules, and they're divided into 2 courses. In order to access the course, you just click on the picture and then click access. And so I already have an account, but if you don't have an account, you just provide some basic information and click here, create a free account. I'm just going to go ahead and log in because of time. So it lists the 3 courses here, and you just click on them. And as part of this, we are going to be providing technical assistance to accompany these modules. So that's all I have to share, unless you have specific questions about the modules. I want to save more time for the questions I know that have come in. So.
Oh, thank you so much, Brian, Amy, and Betsy. You guys are amazing. We're going to go into Q&A now, and I think, Amanda, will you help us with the Q&A portion? But while we're getting to that, I wanted to add that I think there were a couple of people who were confused. Again, ACT and AOT are pretty much the same thing. It's just that in other parts of the country, they call it AOT. So every time you saw AOT, it really just means ACT locally. And also, we will send you tomorrow a link to the video recording, the link to the SMIadvisor as well as a survey so that we know and we hear from you, our community, what we can do to improve. And we always want to hear from you. So Amanda, do you have any questions? Do we have any questions?
Yeah, there's a couple in the chat. So one of them is there CME for this conference?
Okay, so the CEUs and CMEs are part of the SMI advisory when you do those modules that Amy was talking about. And we will send you more information on that. Today was a general overview of the program as well as how to access that module training. And so more information will be sent out.
So, excuse me, so unfortunately, the modules do not have CEUs for social workers or counselors. They only have for physicians. The rest of the information on SMI Advisor have social work credits and psychologists, nurses.
So what we're doing locally is that locally we're going to be providing CEUs for ADAD and certified peer specialists. We didn't get approval for the NSAW because they've not done an online Zoom format as of yet. So we didn't quite qualify for that one yet. But if you do want CEUs for ADAD or for certified peer specialists, we are working with those modules that when you complete them, you'll do a little survey and we'll get notified and we will be able to give you CEUs from the Hawaii state.
So another question we have is, what is the fee for the course and will these slides be available and distributed?
Take that, Amy.
Everything is free, free.
Yes. So it's
Even though one-on-one consultations with psychiatrists through SMI Advisor are free. So take advantage of those. Those are great.
So I want to also explain that back in March, we asked some of you folks to pay for partial coverage of our banquet fees and our food service fees. And I did send multiple emails out to those people who did register back in spring that we can offer you a refund for that. If you'd like it, send me an email. But if you do not request an refund, that funding will go towards this training, because what we're going to also be doing is a follow-up in January, a wrap-up to kind of answer some of the questions you may have, how to get this more detail implemented here locally. So all of our friends here from TAC are going to come back in January and we're going to be able to do this. And hopefully maybe when COVID is gone, we will be able to invite them live, hopefully. So we'll see what happens. But again, those funding will help to support this program locally. But it's free.
Thank you. Did you want me to pull questions from the Q&A box as well? Okay. The first one we have is, have you noticed if the courts have been granting AOTs?
Yeah, so I'm not sure if the question is specifically about Hawaii, which I couldn't speak to, but certainly in the AOT programs around the country we work with, it's actually very rare for the court to find that AOT criteria have not been met. They are almost always granted simply because the mental health system tends to do its homework and make sure that they're only bringing cases where they really got the the documentation of the person's struggles and psychiatric testimony that backs it up. So it's certainly possible that the judge will say, I don't see the evidence here, but it's not very, very common.
I want to also interject, and I realize that we did hit 11 o'clock, and I know some people do have to go back to work. So we want to say we will wrap things up for now. However, if you have more Q&A, we're going to stay on. So if you want to get your questions answered, all of us are going to be here staying on. But if you do have to go back to work or go back to teaching your kids, we're going to say goodbye, and we will send you a follow-up email tomorrow. And we thank you for participating with us, and we hope that you will continue with the module training and the wrap-up in January. So thank you very much for joining us today. If you want to stay on again for the Q&A, stay on. Don't hang up. Don't log us off, but we'll continue with the Q&A. But those who have to go, aloha. Okay, let's go with, we'll continue with the questions.
Great. So next one we have, why has Hawaii failed to successfully use the existing ACT law in your opinion? Too expensive, no program/coordination?
Yeah, no, that's a great one. And I don't know that I'm really super qualified to answer it because of, the distance that we have. Maybe, there's somebody more on the ground who can really speak to what the frustrations have been. I'd actually like to be more in learning mode on that. I know there have been some frustrations with the language of the law. There were some thoughts that some of the law was a barrier to making it work that I think we've cleared up a lot with the amendments made in 2019. But in terms of the practical issues that have prevented this from really getting off the ground, I don't know, Kumi, do you want to maybe speak to that?
I'm still learning, so I don't know all of the details, but what I hear from the communities and from judges and lawyers and so forth is that the law was not very clear. And so that was hard to interpret, but I believe the new bill last year has clarified some of that. And
Yep.
So we are moving in the right direction. If I'm wrong, please someone correct me. I'm always open to learning as well.
Great, thank you. Next we have, do you have any resources for family members and non-lawyers to file ACT petitions?
Yeah, I mean, it's something that we could probably help somebody with, just if they just wanted to get in touch with us and have a conversation with us. Betsy works with family members a lot. I think we could probably help you make that happen. I will say though, again, that from my point of view, when it comes down to the family member having to file the AOT or ACT petition, to me, that really represents a failure of the system to really get a good program up and running. To be the petitioner in an AOT case, for one thing, it means you've got to have an attorney, right? That you've got to hire. It also means you have to kind of play the heavy with your family member, which a lot of families would really rather not do. They're the ones who are imposing this upon them. So I think, in my experience, most family members would really be much happier to be in a place where there's an AOT program that will take it from here. Once you've identified that your loved one is someone who could really benefit from this, there should be a program that you could call a hotline and say, hey, can you please look into whether my person meets criteria, and let them do the petitioning. To me, that's evidence of a much more functional system. So I think there's some sadness in it ever coming down. To me, the idea of the family petitioning, although I think it should be possible under the law, to me, it's like, as a last resort in case of emergency, break the glass kind of a thing.
Thank you. Will petitions for ACT also require lawyers to initiate?
The petitioner has to be represented by counsel. And, where you have a program, it's going to be basically the same attorney who represents the system when you're doing an inpatient civil commitment, right? When a hospital determines a person meets criteria who's been brought in on an emergency hold, they meet criteria for inpatient hospitalization. There's a civil commitment hearing that takes place in that situation as well. So who represents, often it's the district attorney or the county attorney. Sometimes it's the hospital's own counsel. But however it's been worked out in a particular county as to who is going to represent the petitioner in that situation is generally who's going to take that same role in an AOT program.
Thank you. Next we closed our state mental institution years ago. Is there not a need for those? And it just disappeared, so maybe they withdrew their question, so I'll move on.
Okay.
Let's see here. How would individuals with SMI be able to receive services if there is a breakdown of services / communication from their case managers, for example?
Do you want to take that one, Amy?
I'm sorry, I'm answering questions as we go to try and get through them. What was the question again? I am so sorry.
That's okay. Yeah. How would individuals with SMI be able to receive services if there is a breakdown of services / communication from their case managers, for example?
So is this in the context of a court order or not?
I think so. I think that's what it is. Yeah.
So a very important piece of case management when working with someone in a court order is outreach and assertive outreach. So not just a phone call or a letter, but if there is non-adherence, if a person does not adhere to their treatment plan, it's case managers should be the first ones to reach out with a home visit if possible. So Janice, if you want to contact me directly, I will put my email on in the chat here.
Yeah.
So I have a question in relation to that, is that oftentimes we hear people who, from the family members saying our case manager's MIA, or they're on leave for a month, or their cases, they have too many cases and they only give my son 5 minutes. So, you know, is it something that we need to educate our case managers specifically for this program sometime in the future?
So that's a fabulous question. And that's something Brian talked about in his presentation. It's not only a court order for the person receiving services, it's also a court order for the mental health center. So, you know, they're under order to provide the services, and if their case manager is MIA, then the supervisor needs to reassign that case as quickly as possible. I mean, these are the high priority folks, and so they need to be at the top of the list when being reassigned.
Yeah, and just in terms of, you know, impressing upon everybody that this is a mutual commitment. You know, the patient retains counsel. The person continues to have an attorney representing them for all the time that they are on AOT. And if it becomes apparent they are not getting the services they have been essentially promised, right? When that treatment plan got incorporated into the court order, that became a vow of the system to provide this person with these services they need. And, you know, that's something that through counsel can be brought back to the judge's attention. The judge can bring the parties back into court for another hearing and say, hey, this is not what's been promised to this person. And that can be very empowering for the individual just to be told that at the beginning, that you not only have responsibilities here, you also have a right to expect good treatment.
Excellent, excellent.
Thank you. Let's see here. Next one is, I think there is no point persons paid by the state to bring a petition, no resources in Hawaii, costs $10,000 or more for a family member to hire an attorney, and then must get someone in the field to serve the SMI and then pay for a psychiatrist, which the SMI will not see. What does one do?
Yeah, well, I think that's really speaking to the importance of building a program in a community if we're going to have any expectation that this is actually going to happen. So as long as it's just a legal proceeding that's possible with no program built up around it, you know, I think the questioner is absolutely right that it's unrealistic to expect anyone's ever going to bother filing these petitions, because the family member is the only one with a real incentive to, and there are huge barriers to them doing that. But if you've had a community come together to say, we are going to use this power, we're going to identify all the folks coming out of hospitals who meet these criteria, and we're going to cross all those T's, right, and dot those I's in advance and come up with a plan for how we're going to make sure those petitions get filed and who's responsible for it. If you have a protocol where the doctor in the hospital identifies their patient as meeting criteria, and the social worker who's doing the discharge plan lets the AOT program know, hey, we've got somebody who we're releasing next week who we think is a really good AOT candidate, you know, all those pieces along the chain lead to the triggering of the petition by the program itself. And, you know, it takes a concerted effort to make it happen, but it's the very thing we want to work with everyone to accomplish. Because if we don't get programs, we're not going to get AOT cases.
Thank you. Do you think that the national dialogue on seeking alternatives to law enforcement intervention in mental health will affect the reception, for good or worse, of laws or programs such as this?
I think it's going to affect it for the better, by all means. This is a perfect example of the kind of things you can do. You know, there's this really important model that's been developed in the diversion realm called the sequential intercept model, where they try and identify all the points. They do sequential intercept mapping in many communities, where they try to identify all the points along the criminal justice process where you have opportunities to divert people out of criminal justice into mental health treatment. AOT comes into play at what we call intercept zero, right? If you can get people into AOT, then you never have a criminal act committed in the first place, because we have so many studies that show us how effective this process is in keeping people engaged with treatment, which just prevents them from committing crimes at all. The data on that is just so compelling that as people become more aware of the need to do diversion, they will realize that this is something you do along with this is a diversion strategy. It diverts people from ever getting in the first place. So
And Honolulu has done the intercept model,
Mapping,
and we're
yeah.
working the mapping with CIT, a team of collective people in law enforcement and government. And so we should revisit that, definitely. So thank you for bringing that up, Brian.
yeah, great.
Okay. Next we have, does the mentally ill person you are petitioning ACT for have to show up in court? A big barrier is often finding our clients who are homeless to inform them of court dates/appointments.
Yeah, so that's a good question. The answer under the Hawaii law is no. We should make clear, first of all, that if you're using this in the typical way as people are coming out of the hospital, getting them to appear is not an issue, right? Because you're going to hold the hearing just before the person is discharged. So you can just you could ideally do the hearing at that courtroom. I assume you have hospitals that have courtrooms in them where they do inpatient hearings. You can use those same courtrooms to do outpatient hearings before people leave. And then it's not a question of they're in the community already and we hope they're going to show up. But where you are using this is what we call step up AOT. That is for somebody who is currently in the community, who you want to use this to prevent them from reaching the point where they get committed to the hospital. And you hope they're going to come to the hearing, but if they don't, the Hawaii law says that the court may appoint a guardian ad litem for the person to represent them and essentially, in effect, be them at the hearing, and represent their interests at the hearing, even though the person is not there. So they don't have the opportunity to derail the whole process by not showing up.
Great, thank you. Next we have, I'm not sure, but asking CM from other agencies has been a challenge, and I understand they may be overwhelmed and you can't call the agency. They are not expecting any calls at this moment. The CM phones are full, so if possible, CMs may need support or encouragement. I guess there's not a question there, more of a comment.
What does CM stand for?
Case manager.
Oh, case manager, of course, yeah.
I will say that it's important if you're going to be implementing ACT that you have the services available. And I understand that Hawaii has a considerable, as Brian mentioned, shortage of workforce. And so, case management isn't going to be as plentiful as it may be in other places. But I am always one for offering support to case managers because they are the bedrock of all mental health treatment, as a former case manager myself.
Thank you. Let's see here. Looks like that's all the questions in the Q&A box, just some comments. Thanking all of you for your expertise and advice.
Pleasure. Yeah, and we put our email addresses up somewhere, I hope, so that people can just keep throwing us more questions as they think of them. And, engage,
Yes.
if you want to just have conversations with us about how you can actually make this happen in your community, we would love to set up, small group chats with anyone who has that interest.
Definitely. I will be able to share that with all of our attendees and all of our registrants. And that last comment came from Anson Rego, our advisor. He's actually a lawyer, and he said, Brian, thank you for that wonderful information. So I think this will conclude our event today, and we're so grateful. We had a good turnout. We had some good questions. I think it's a great start. There's so much more to come. So we will definitely get you connected with all of the emails from today's panelists. And otherwise, we will see you in January. Thank you, Brian. Thank you, Amy. Thank you, Betsy and Amanda for all that tech support. Thank you, everyone.
Thanks,
Okay,
guys.
aloha, everyone.
Thank you.
Okay, good night.
Bye.
Good night.